You open your door one morning and your stomach drops. The police are outside, only this time, your doorbell camera isn't showing you anything. The feed is black. They've covered it. And in that instant, your home, your privacy, has become the scene of someone else's operation. Let's be very clear. When law enforcement covers your doorbell camera, it means one thing. They don't want you to see what's about to happen. And depending on how you respond, that moment can either protect your rights or destroy them. I'm a lawyer, and I've seen both sides of the situation. The citizen who panics and loses everything, and the one who stays calm, follows protocol, and walks away legally bulletproof. So today, I'm giving you the inside playbook, 20 essential tips for when cops cover your doorbell cam, what it means, what you can do, and what you absolutely shouldn't do. Tip 1. Understand what it legally means when they block your camera. When officers cover or disable your doorbell cam, it's rarely random. It's an operational tactic, often tied to warrant execution. That means they already have judicial authorization to enter, or at least believe they do. In legal terms, they're operating under color of authority, which gives them temporary legal justification to limit your observation of their activity. But here's the nuance most people miss. Covering a doorbell camera doesn't automatically make their actions lawful. If the warrant is invalid, expired, or improperly executed, their attempt to conceal can later be used to challenge the legality of the search itself. So, your first move isn't confrontation, it's documentation. Don't touch the door, don't yell through it. Quietly activate secondary cameras. If you have another exterior angle, motion detector, or indoor view that faces the entrance, record it. Timestamp everything. Because if that footage captures officers obscuring your camera before announcing or serving a warrant, your attorney can later argue suppression by concealment, a Fourth Amendment violation rooted in lack of transparency during the execution of a search. Courts have thrown out evidence on that exact basis. Why it works. The Fourth Amendment guarantees you protection against unreasonable searches. That protection doesn't vanish because an officer has duct tape. The moment they obstruct your view before identifying themselves, they risk invalidating their own operation. Tip 2. Don't open the door. Communicate through it. If your feed goes dark, your first instinct might be to open the door. Don't. That's one of the biggest mistakes people make. The moment you open that door, you're surrendering a layer of legal protection, because officers can interpret that as consent to enter. Instead, speak calmly through the closed door. Officer, please state your name and agency. Do you have a warrant? Ask them to slide the warrant under the door or hold it up to a window. That's a legal and reasonable request. Under U.S. law, you have the right to review the warrant before complying. You do not have to open the door to verify it. If they refuse, say clearly and audibly, "I do not consent to entry without a warrant." Then step back. Stay silent. Let your camera's microphone record your statement. That line alone, captured on audio, has protected countless defendants by showing clear refusal of consent. Why it works. Courts distinguish between voluntary compliance and submission to authority. By refusing calmly and requesting the warrant, you establish that you're aware of your rights and not giving consent under coercion. It creates a legal firewall that limits how far officers can stretch implied permission. Tip 3. Know when it's a knock and talk versus a warrant execution. Many officers use knock-and-talk visits as fishing expeditions. They're not there to arrest you or search yet. They're hoping you'll open the door and start talking. And if you do, anything you say can be used against you, even casual small talk. When they cover your camera during a knock-and-talk, it's psychological manipulation. They're removing your sense of control to provoke anxiety. Don't fall for it. If they have a search warrant, they'll usually announce it. Police, search warrant. If they don't announce that and simply say they want to talk, it's not a warrant. You can legally refuse. Just respond through the door. "I don't wish to speak without my attorney." End of conversation. Why it works. Under Kentucky v. King 2011, the Supreme Court reaffirmed that police can knock and talk, but they can't create exigent circumstances, meaning they can't cover your camera or intimidate you into compliance. Doing so crosses the line from conversation into coercion. Your calm silence preserves your constitutional armor. Tip 4. Document the covering tactic immediately. As soon as you notice your camera is obstructed, note the time, date, and what you observed. Afterward, check your system. Logs. Most smart doorbell systems, like Ring, Nest, or Arlo, retain metadata even when the feed is cut. This can include motion detection timestamps, disconnection attempts, or suspicious network spikes. That digital evidence is gold. It shows when the interference started and whether the police identified themselves before doing so. Next, file a data preservation request with your camera provider. This forces the company to hold your cloud footage while your lawyer investigates. Without that step, your footage may automatically overwrite in 30 days. Why it works. Documentation isn't just about proving misconduct. It's about creating a timeline of events. The moment your lawyer can correlate a camera offline event with a lack of knock, you have a potential suppression argument for unlawful entry. Tip 5. Keep your mouth and hands still. This one's simple but critical. If they cover your camera and you see flashing lights or hear movement outside, your adrenaline spikes. That's when people make the worst legal decisions, grabbing their phone, opening windows, or shouting out. Don't! Every movement you make is being recorded, from body cams, car dash cams, and possibly drones. Those recordings will later be dissected in court. The calmer you are, the stronger your defense looks. If they break the door, don't resist. Step back, hands visible, and repeat, "I do not consent to this search." That line, repeated once, establishes your position for the record, why it works. In legal analysis, resistance, verbal or physical, can transform a constitutional violation into a lawful arrest under obstruction statutes. But nonviolent noncompliance keeps your legal standing intact and preserves your right to challenge the entry later. We've covered the foundation, understanding what's happening, asserting your rights, and securing evidence without escalation. But this is just the beginning. Next, I'll break down what happens after they've covered your camera and entered, what you must do in the next 10 minutes to protect yourself legally, financially, and personally. Because once they're inside, the real battle begins, and how you respond in those minutes can determine whether you walk away free or face charges that shouldn't have existed in the first place. Once the police are inside your home, the power dynamic shifts dramatically. They've already decided that whatever they're looking for justifies intrusion. Your goal from this moment forward isn't to argue or resist, it's to strategically preserve your defense. Every move you make must protect your future, not your ego. Let's walk through what happens next, step by step. Tip 6. Identify the type of warrant, search, arrest, or no-knock. The first thing you need to understand is what kind of authority brought them in. There are 3 common scenarios. 1. Search warrant. They're authorized to look for specific items or evidence listed in the warrant, nothing more. 2. Arrest warrant. They're here to take a specific person into custody. Their search authority is limited to ensuring safety and locating that individual. 3. No-knock warrant. They've been granted permission to enter without announcement, often justified by risk of evidence destruction or officer safety. Each has different boundaries. When you regain composure, calmly ask, "Can I see the warrant, please?" They're required to show it as soon as it's safe to do so. You can't physically demand it mid-operation, but you can, and should, request it verbally on camera. That request, captured on body cam, becomes part of the record. Once you get access, read the scope carefully. Look for the address. It must match your property exactly. The judge's signature and date. The items or names listed. If anything is off, wrong address, expired date, missing signature, your attorney can move to suppress all evidence seized under the exclusionary rule. That means the evidence is thrown out as illegally obtained. Why it works. Search and seizure laws are strict because they balance power. When officers exceed their warrant scope, it's considered constitutional overreach. Federal courts have suppressed entire cases because of such technicalities. Tip 7. Do not direct or assist their search. When adrenaline takes over, many people try to cooperate to seem compliant. Pointing officers toward rooms or answering questions like, "What are you looking for?" Don't do it. That's called constructive consent, and it can legally expand the scope of their search beyond the warrant. By cooperating, you're unintentionally authorizing them to go beyond the judge's order. Your only line should be, "I'm not resisting, but I do not consent to any search beyond the warrant." Then stay silent. If they ask about digital devices like phones or laptops, remember, your passcode is protected by the 5th Amendment. You cannot be forced to reveal it. However, biometric unlocks, like fingerprints or Face ID, can be compelled in certain jurisdictions. The best move? Disable biometric access before opening the door if you ever anticipate a confrontation. Why it works? Courts have consistently ruled that verbal consent nullifies later challenges. The moment you start explaining or helping, you're granting them expanded access. Silence keeps their authority contained. Tip 8. Never lie, but never volunteer. Anything you say during a search is admissible in court. But here's what most don't realize. Lying to police is a crime, while staying silent is not. Under 18 U.S.C. Paragraph 1001, making a false statement, even a small one, can result in felony obstruction charges. So if an officer asks, "Is there anyone else in the house?" and you're unsure or afraid, simply say, "I choose to remain silent until I speak with my attorney." That's not defiance, it's precision. Why it works. Silence is a constitutional right under Miranda v. Arizona, 1966. But you must clearly invoke it. Once you do, continued questioning becomes legally problematic for the officers, and your lawyer can use that to suppress statements or dismiss charges based on coercive questioning. Tip 9. Watch for scope creep. During the search, Scope creep is when officers start looking beyond what their warrant allows. For example, if the warrant specifies narcotics in the kitchen, but they're opening drawers in your bedroom or attic, that's outside the scope. Stay calm, stay observant, and say once, clearly, I want to note that area is outside the scope of the warrant. Then stop talking. If you have a secondary recording device, like a phone placed discreetly, let it run. Don't film them directly unless your jurisdiction allows it. Instead, record ambiently. Even partial audio can later establish that the officers exceeded their mandate. Why it works. Evidence found beyond the warrant scope can be excluded under the fruit of the poisonous tree doctrine. That means anything derived from an unlawful search becomes inadmissible. Courts treat scope violations harshly because they demonstrate bad faith. Tip 10. Secure witnesses and preserve your mental notes. If anyone else is home, family, roommates, neighbors, have them take note of times, actions, and officer names. After the search, write everything down immediately while it's fresh. Include the time your camera was covered, the first words the officers said, whether they knocked or announced, every area they entered. That's your post-event affidavit, and it can be the difference between a dismissed case and a conviction. Why it works. Human memory degrades fast, especially under stress. Courts often favor contemporaneous notes as more credible than delayed recollections. A time-stamped, detailed account shows consistency and reliability, exactly what defense attorneys need to dismantle contradictory police reports. Tip 11. Request an inventory of seized items. When the search concludes, officers must leave behind a receipt or inventory of everything they took. That's not optional. It's codified in Federal Rule of Criminal Procedure 41 ICAF 1. C. Before they leave, ask, "Can I have a copy of the inventory, please?" If they refuse or say it'll be mailed later, record that refusal on audio. Then follow up in writing with the department within 24 hours. The inventory establishes a chain of custody, proving what was seized and preventing tampering or additions after the fact. Why it works. Missing or incomplete inventories are a red flag in court. If the prosecution can't show an unbroken chain of custody from your home to the evidence locker, your attorney can argue contamination or fabrication, often leading to suppression. Tip 12. Contact an attorney immediately, not tomorrow. Once the officers leave, most people take a breath, call family, and wait. That's a mistake. You need to call a lawyer immediately, ideally within the hour. The first few hours after a search are when reports are written, and your lawyer can start preparing rebuttals, witness statements, and data preservation requests. Don't post on social media. Don't text friends about what happened. Every post, every message can later be subpoenaed as evidence of your state of mind. Instead, text one line to your attorney. Police conducted a search at my home today. I need representation immediately. Then stay quiet. Why it works. Early legal intervention preserves your rights while evidence is still fresh. Your lawyer can send preservation letters to your camera company, file notice with the DA, and request copies of the warrant before it's sealed. That early control prevents surprises later. At this stage, you've survived the initial contact and minimized exposure. You've asserted your rights, documented their actions, and preserved the evidence you'll need. But your battle isn't over yet. Next, we'll cover what to do in the days that follow, how to handle post-search, interviews, property retrieval, and how to build a defensive strategy that protects not just your freedom, but your reputation. Because when law enforcement covers your doorbell camera, it's not just about that moment. It's about the story they're trying to write about you afterward. And if you're not careful, they'll write it before you even get a chance to speak. The search is over, but the aftermath is just beginning. If the police covered your doorbell camera, it wasn't random. They wanted control of the narrative. Now your job is to take that control back, strategically, legally, and quietly. Because in the legal system, the first version of a story that reaches the file tends to become the truth. Let's make sure it's yours, not theirs. Tip 13. The first 24 hours. Control the narrative before it controls you. After any police entry, the most damaging thing you can do is start explaining yourself to friends, neighbors, or online. Every word you say becomes discoverable. Even casual statements like, "they didn't find anything," can be twisted into, "he expected them to find something." So your immediate steps should be simple and deliberate. 1. Write a private timeline. Everything you remember from the first knock to their exit. Keep it for your attorney only. 2. Store all related footage and metadata in a cloud folder labeled Attorney Privilege, Do Not Delete. 3. Refrain from posting. Let your lawyer manage all communication with media, police, or investigators. If you must say anything to family or work, "There was a misunderstanding. My attorney is handling it." That's it. Why it works. Silence is a legal shield. The prosecution can't misquote what you never said. The fewer offhand comments exist, the easier it is for your lawyer to present a clean, consistent defense without contradictions. Tip 14. Get the incident report and warrant return. Every search generates paperwork. Within a few days, the executing agency must file a warrant return. A report summarizing what was done, what was seized, and why? That document is public record once filed, and it's your first real look into how they justified covering your camera and entering your property. Go to the clerk's office or have your attorney request the search warrant application, the affidavit of probable cause, and the return inventory list. Compare these with your notes and recordings. Was the reason for the warrant truthful? Did they actually limit their search to what's described? Did they mention disabling or covering your camera? If not, that omission can be powerful evidence. It shows selective reporting and intent to conceal, which bolsters your Fourth Amendment challenge. Why it works. The warrant return locks officers into a version of events. Any later contradictions, especially if you have footage showing something they omitted, become credibility issues in court, which can weaken the prosecution's entire narrative. Tip 15. Demand a digital forensics report if devices were taken. If your phone, laptop, or hard drives were seized, you have the right to know what's being accessed and when. Under federal law and most state procedures, law enforcement must generate a digital forensics report documenting extraction dates, tools used, and scope of data reviewed. Your attorney can file a motion for inventory inspection or return of property. Until you get those devices back, assume every file, message, and password is being examined. That means change all passwords immediately, revoke access on synced accounts, enable two-factor authentication for everything. Why it works. Digital evidence is fragile. If officers exceed the scope of a digital warrant, for example, accessing files unrelated to the investigation, that can render the entire forensic search unconstitutional. The audit trail in the report becomes your proof. Tip 16. Track every official contact afterward. Once they've entered your home, you'll often get a follow-up call or friendly visit from a detective. They'll frame it as a clarification or routine check. Don't fall for it. This is an interrogation in disguise. When contacted, say, "Thank you for reaching out. My attorney will get in touch." Then hang up. Immediately record the date, time, and name of the officer. Forward that log to your lawyer. Even if they say you're not a suspect, remember, you're under investigation until formally cleared. Why it works. Every unsolicited contact is an opportunity for them to secure a statement or reaction that fills a hole in their case. Refusing direct communication ensures every interaction goes through counsel, keeping you legally insulated. Tip 17. Analyze whether their camera covering violated your rights. Now that emotions have cooled, your attorney can begin dissecting the core issue, the doorbell cam cover. Was it justified under law enforcement policy, or was it excessive? The key questions are, did they have a warrant when they obstructed the camera? Did they announce their presence first? Did they document the action in their report? If any answer is no, your lawyer can argue procedural misconduct or concealment of evidence. Federal courts have ruled that recording your own property and police activity from your doorstep is a First Amendment right, as long as it doesn't interfere. By covering your camera, they potentially violated both your First and Fourth Amendment protections. In cases like Glick vs. Cunife 2011, courts affirmed that private citizens have the right to record police performing official duties in public spaces. That extends to your property. Why it works. When police act in ways that obscure accountability, judges often interpret that as bad faith. Even if the search itself is valid, procedural misconduct can lead to suppression of evidence or internal disciplinary review, both of which can benefit your defense. Tip 18. File a Freedom of Information Act (FOIA) request. If your case isn't sealed, you or your attorney can request body cam footage, dispatch logs, and operation memos through a Freedom of Information request. Many departments resist this, but the law requires a response. These records can reveal whether officers discussed disabling your camera, the timing of their entry versus your footage blackout, internal inconsistencies in their story. Even a redacted report can expose procedural flaws. Why it works. FOIA requests pull the truth from behind the curtain. They convert speculation into evidence, which shifts power from law enforcement back to you. And once your attorney has those documents, the case strategy becomes proactive instead of reactive. Tip 19. Assess civil remedies. After the case ends, if it turns out your rights were violated, say, they covered your camera without a warrant or damaged property without justification, you may be entitled to civil damages under 42 U.S.C. Patriot 1983. That's the statute that allows citizens to sue government agents for constitutional violations. Successful suits can recover property damage costs, legal fees, and monetary compensation for emotional distress or reputational harm. However, timing matters. Most jurisdictions have statutes of limitation ranging from 1 to 3 years. Your lawyer should send a notice of claim early to preserve your right to sue later. Why it works. Accountability isn't just criminal, it's civil. When departments face financial liability, they often change their operational policies, preventing future abuses. Your action doesn't just protect you, it creates precedent for everyone watching. Tip 20. Build a long-term safety strategy. After a situation like this, your goal should be prevention and empowerment. Strengthen your personal defense infrastructure. Install redundant camera angles that can't all be blocked simultaneously. Use cloud backup systems that trigger alerts if a feed is interrupted. Keep an encrypted off-site backup of footage. Establish an emergency protocol with family or roommates. Who calls the lawyer? Who documents? Who stays silent? Most importantly, educate your household. Rights mean nothing if people panic in the moment. Rehearse calm, lawful responses to police presence. Because in those few seconds when someone covers your camera, preparation is the only thing between you and a bad outcome. Why it works. Consistent training creates instinct. Instinct prevents escalation. Escalation destroys rights. The best defense isn't confrontation, it's controlled awareness. When police cover your doorbell camera, they're trying to turn off your eyes. But knowledge turns the lights back on. You now understand the law, the tactics, and the psychology behind it. The next time that lens goes dark, you won't react out of fear. You'll respond from strategy, calm, calculated, legally armed. Because real power doesn't come from arguing with the police. It comes from knowing the law better than they expect you to. Stay informed, stay calm, and never surrender your rights at the door. That's how you win. Not by confrontation, but by control. I help you to protect yourself. And this channel exists to give you the law before you need it. Because once you're in the moment, it's too late to learn it. So for more of such content, click on the card showing on the screen.